Good afternoon, everyone. I hope you can hear me. You're welcome today to the NBA-SBL Business Law Weekly Series. This is the third season we're in, and this is episode 11. And the title of our topic today is The Bolts and Knots of Negotiating Construction Contracts. This session is hosted by the Construction Projects and Infrastructure Committee of the NBA-SBL, ably chaired by Andrew Odom, SAN, our learned silk. And he's our host for today's session. Of course, our eminent speaker and guest today is Mr. Emmanuel Dike. He'll be introduced in due course. And my name is Yetunde Olasope. I'm the secretary. I serve as secretary for the committee. In observing all protocol, of course, welcome our chairman, Mr. Odom, SAN, and of course, all council members of the SBL. We thank you for the leadership that you provide to our organization, and thank all those in attendance, especially our chairperson, Mrs. Ozofu Ogemudia, and all other members. We also acknowledge all participants. Thank you for joining us today. Hopefully, it would be a session, worth its while. Without further ado, I will now hand over to our host and able chair, Andrew Odom, SAN, our learned silk. Over to you, sir.
Thank you, the very distinguished secretary of our committee. Thank you. On behalf of the Construction Projects and Infrastructure Committee of the Nigerian Bar Association Section on Business Law, I joyfully welcome all our members across the country and beyond to this NBA-SBL Business Law Weekly. We're grateful to the chair of the SBL, Ozofu Latunde, and the SBL Council for another opportunity of this channel. May I especially welcome the chairman of the International Constructions Project, ICP of the IBA, International Bar Association, Virginie Kolayuta, and members of the IBA ICP, some of who have assisted to publicize this webinar in other parts of the globe. We're grateful for the present and future collaborations with the IBICP. This is our third outing this year on this channel. And each of the previous webinars were well attended and the feedback profound, almost overwhelming. To be a member of this committee, you must first become a member of the SBL and indicate your plans for this all-important committee. I also invite you to consider to join the ICP of the IBA to internationalize our practice in this area. We're planning our second National Constructions Conference, and we'll communicate everyone concerning the date and the details in the coming days and weeks. We are beholden to our members, Mr. Emmanuel Dike and Yetunde Olasope, for their great resources and charity. Thank you very much. Now, what remains for me is to enjoin all of you in Nigeria, all over the world, to sit back and enjoy this episode. And please remember to give us your feedback as usual. Thank you. Happy listening and participation.
Thank you very much, our learned silk. I knew you were going to do a great job to cover all bases, especially where protocols are concerned. So I stand on those protocols and thank everyone for being here. As we said already, we're looking to make it as interactive as possible. So there's a Q&A box that you should please impute your questions, comments, observations, etc. So please, we will give time during the session to address as many questions as we can. As you know, we have a very short slot allotted. It's an hour's session. We will try our best to be as thorough as possible, but also trying to, summarize as much as possible. Hopefully, we'll have other avenues and fora where we can, dive deeper into this topic. So without further ado, I'm going to introduce more formally our erudite and able guest for today, Mr. Emmanuel Dike. I'm going to read a short profile. It doesn't quite do justice because we have to shorten it for the time we have. And then we will, just for everyone to know about him, and then we will dive immediately into the question and answer the session, the moderation session, which we're modeling after a fireside chat. So, Mr. Emmanuel Dike practices law as the senior partner in the law firm of Jasmine Advocates. It's a full-service law firm based in Nigeria with significant international exposure and affiliation. He's also the chairman of the Society of Construction Law, Nigeria, as well as the Secretary General of the Institute of Construction Industry Arbitrators. He was the winner of the Who is Who Legal Award as a national leader in arbitration and construction matters in 2021. In recognition of his deep understanding and skills in resolving construction disputes, Mr. Dike has rendered legal advice and represented parties in courts in many construction-related contracts, such as lump sum contracts, EPC contracts, dredging contracts, HSC contracts, that's health, safety, and environment, etc. There's so many. He advises construction companies, professional bodies in construction industry, in the construction industry, and also government agencies. He is very versed in construction matters and construction dispute resolution. He's conducted several and dozens of construction adjudication cases, both international and domestic, under the FIDIC suite of contracts and all the dispute resolution mechanisms used, boards. Finally, as I said, it's a summary and it doesn't cover his whole profile. Mr. Dike is a long-standing fellow of 3 prominent arbitration institutes, including the Institute of Construction Industry Arbitrators. He's a fellow of the Chartered Institute of Arbitrators UK, and also a member of the Nigerian Institute of Chartered Arbitrators. I think he's also a fellow there, my mistake. So welcome, Mr. Emmanuel Dike, and thank you very much for your time today.
Thank you for that generous introduction. I look forward to a very pleasant day.
Thank you. As I said, I mean, your reputation speaks for itself. Your profile is replete with all sorts of accomplishments. We just had to, summarize in favor of the time that we have today. So our topic, the bolts and nuts of negotiating and drafting construction contracts. That's what we're going to discuss today. And as the title connotes, nuts and bolts, it's going back to the practice, the nitty-gritty, the practical side of negotiating construction contracts. And Mr. Dike is going to help us in this regard today from his wealth of experience. So without further ado, we will jump into the first question. Who are the typical parties in a construction contract, and what are their roles, the key roles in a construction contract and the parties in there? Because we want to start with the basics and then build up as the session progresses. Thank you.
Thank you very much, Yetunde. Straight to the question. The typical parties in a construction contract are basically 4 groups. 1, the employer. 2, the contractor. 3, the subcontractor. And 4, consultants. Their roles, for instance, the employer is the owner of the work. In some instances, it's referred to as the client, depending on which contract you are looking at. So he is the one that authorizes the work to go on. He has the also the purse power. He is the one to pay as well. And at the end of the day, the job is handed over to him. Then we have the contractor, who is basically the person that takes charge of the overall construction work to implement the terms and conditions of the contract. He need not be a specialist in any area of construction, but he organizes the work and ensures that the job is delivered on time. However, there are subcontractors along the line. These subcontractors, they undertake specific areas of the work. Might be the area of specialization, and they're asked to deliver services in that regard. But they all come under the contractor in the main contract. They don't have their own separate contract most times, because they are going to work for the contractor. And if they have any claim at all, they will claim from the contractor, not the employer, even though they are also probably mentioned or they're recognized under the contract. And some of these subcontractors include suppliers of materials as well. Sometimes the employer might recommend certain subcontractors and suppliers. In that instance, they are regarded as nominated subcontractors or suppliers. The contract will also cover them. And then there are consultants, numerous consultants, especially professionals in the industry. You have architects, engineers, several engineers, quantity surveyors, and other practitioners in the industry who are engaged as consultants, possibly through some separate contracts. May not be just one contract that would capture every bit of work in a construction project. I think that's just what I have to say there.
Thank you very much. That was very helpful. So sometimes we find an interchange of use between employer, owner. Is there a distinction? Are they the same? Is there any distinction? Or are they interchangeably used depending on what jurisdiction or what set of contract forms that are being utilized in a project?
Yes, I said it earlier that the employer is actually the owner of the work. Okay. However, in some instances, it might be described as a client, depending on the contract condition you are using. Okay, so they all mean the same person and point to the same person, the owner of the job.
Thank you for that clarification. It's very important to make. And these terms would be, subsequently used in our discussion. And it's important, as I said, to build those blocks of understanding. So next, what are the essential, elements or components of a well-drafted construction contract? And what are the key considerations? This would be a summary because obviously we're going to dive deeper as we're discussing some of those key elements. So we just want you to quickly go through, the essentials of a well-drafted construction contract and key considerations to bear in mind when negotiating and drafting such contracts.
Okay, here, they're very simple. You've talked about negotiating and also you have talked about drafting. Maybe I should start with negotiating. Okay. When you negotiate a construction contract, you need to understand the business of your client. As a lawyer, you would have to get involved deeper in knowing what kind of business your client is doing, in order to help you understand the industry practice, the nuances of the business, because you need it to be able to properly draft the contract. And moreover, you need to be familiar with the rules, the laws governing that construction project. And again, you also have to realize that you know when to negotiate the risk involved, because understanding the laws and the nuances of the industry will enable you to understand what manner of risk your client is going to face. And all of this boils down to the fact that risk identification is a key in negotiating a construction contract, because the other party will also want to have an idea of how this risk will eventually be allocated in the contract itself. So negotiation is absolutely important, and especially when it is a bespoke contract. It's all about negotiation and what you agree with the other party. But that does not preclude you from also negotiating standard form. There is this erroneous impression that what you have in standard form contracts are sacrosanct. They are not sacrosanct. And what you see sometimes in standard, because they are industry understanding of this kind of contract, and experts come together to put it down. And sometimes they are products of court decisions, that have been tried in court over and over again. So they acquire a kind of industry meaning. So you have to now understand the effect of some of these terminologies when they are used, in order to enable you draft a proper contract without conflict. As I was trying to say, what you see sometimes in most standard form contracts is that if there is an issue that has probably started way back, unresolved, and when you get to when you are using the standard form, you do not pay attention to it as to modify it. That means you easily transport it into your own contract, and that issue will remain there live and a threat to implementation of that particular contract. And that is a potential area of dispute. Okay, so both negotiation and drafting of this of a construction contract, they go together. They go together. And my suggestion is you don't gloss over anything. Take a long, hard look at every clause and query it to know whether it suits the interest of your client. Thank you.
Thank you very much, Mr. Dike. And one of the key takeaways I'm taking from what you've just said is, because it's a standard form does not mean it cannot be negotiated. Yes, there are some terms that over time they're generally accepted, etc. But sometimes it's our colleagues when we're negotiating contracts, and not just in the construction industry, for instance, you get a lot of responses like, well, it's standard, it's the form. But there's some areas that can still be negotiated. So I like that you've said that. And the fact that it's a standard form does not mean that, it doesn't need to be thoroughly reviewed and, edited or updated to fit the particular circumstances of the project at hand. So that's very important. And if we need to take anything away from that as lawyers, I think that's very, very critical. So thank you very much. So we're going to segue into the standard forms from what you've said, because as we know, there are standard forms adopted in the industry. There are many. There's some that are more favored in Nigeria. We know of the FIDIC, we know of the JCT and some others, even the Ministry of Works. In your experience, which ones are more utilized or more favored in Nigeria, for instance? And would that, response change if it's a private contract that we're looking at, or for example, a public contract or construction of for infrastructure, for instance, which of the forms are more favored, the standard forms are more favored in that respect. And as you've also mentioned bespoke, so obviously these can be tailored to the needs of the parties to each contract. I just want you to touch on that. Which of the forms are favored? Is there a reason why one is favored over the other for particular circumstances? If you could just educate us a little on that. Thank you.
Thank you very much. In Nigeria, government is the biggest spender when it comes to infrastructure development. So it's not a matter of being favored. You just have to go along with their preferred contract condition. Construction contract in Nigeria for the public sector is segmented into two, small contract and large contract. So for small contracts, whether it's for building or for roads, the government has a standard form. For building contract. It also has a standard form for roads and bridges. When I mean small contract, maybe contracts that are below 1 billion naira or so. So you can use the standard forms as prescribed by the government, depending on the nature of the construction work. If it is for roads, you have a separate standard form for roads and bridges. If it is for buildings, you have a separate standard form for buildings. But then for large contracts, they also have another standard form, which is called the GCC, General Condition of Contract, that is produced by the Bureau of Public Procurement, BPP. So that's for large-scale contracts. And again, as a policy, you do not have much choices as long as the work is for the government, especially the federal government. So and it's backed up by a law, the Public Procurement Act of 2007. So it's just the way it is for the public sector. But for private sector, most times private sector, especially for small contracts, they go for bespoke contract. They go for bespoke, in which case they are negotiated by the parties and the terms are agreed upon. And maybe it's given to a lawyer to draft. And the lawyer would have the task of ensuring that nothing vital is missed out. Sometimes it's a bit of a tough task because there is no standard conditions to rely upon. But that does not mean that the lawyer would not look at some of those standard forms to borrow favorable terms into the bespoke contract is drafting. But for large private sector projects, what you see is that some of these private sector people that are engaged in large projects are multinationals. And most times they want to use international standard forms, which you have already mentioned, especially the FIDIC contract conditions, or the JCT. And not much is heard about NEC at the moment, NEC, but it's around the corner, and people are looking at it, as the next alternative. And then again, apart from this other, these ones I've mentioned, some of the big corporations, multinational corporations, they have their in-house standard forms that they use worldwide. So again, you are subjected to that as well, not as a matter of choice, but as a matter of a company-wide policy. So you have several. Each multinational would have a standard form that is sent to it from its headquarters abroad, and you just have to deal with that situation because that is what it is. Yeah, Thank you.
Thank you so much for that clarification. So, there's standard forms, but, there's no hard and fast rule. It can be bespoke, and the bespoke ones can even be incorporated, can have some sections or provisions incorporated from the standard forms. The key is, being aware of, what you need to have in those contracts, the key elements, and ensuring that they're in there. And of course, as you've rightly mentioned, there's some instances where you have no choice. It's the power of the negotiating party on the other side, or the employer, as it were, and they have their own standard forms or forms that they have, made bespoke to their own needs over time. So thank you very much for that clarification. You'd mentioned earlier, of course, with the reviewing, negotiation, and particularly drafting of a construction contract, there's a main concern for risk mitigation for the draftsman or whoever is drafting the contract. What are the main risks? Because, that's it. Construction work, as you know, or should I say contracts or projects, high-risk projects. And risk mitigation is very, very critical when it comes to negotiating those contracts. What are these key risks, in a nutshell, that you can identify, and that a lawyer or a legal practitioner or any professional negotiating a construction contract or involved in the drafting, what are those key things that they need to look at and look out for to ensure that, at least there's a good level of risk mitigation and allocation, as it were? Thank you.
Yes, for a legal practitioner, we still have to fall back to my opening statement that it's always good for you to understand the business of your client. Don't wait until some other professionals are finished negotiating the contract and then they give you the contract to draft just to couple together. You probably would not understand the nuances and where they're coming from in that instance. But if you are there from the go, you would know why certain clauses are allowed to be in that contract. Now, having said that, there are so many risks that you might not need to deal with when you are drafting a contract. First of all, a construction project starts with conceptualization, which is design. Someone has to design the work, possibly an architect. So in that instance, there is a risk involved, and it's called a design risk. So depending on the nature of the project, is it a lump sum? Is it an EPC? Is it a BOT or something? That would determine who is going to be in charge of the design, whether it's going to be the employer or whether it will be the contractor. So you should know the nature of the project in order to know where to allocate the design risk. What I mean by design risk is who should be responsible for the design and the fallout of that design in case there is a problem. Who is going to carry the risk of that problem? So that is number one. The number two is construction risk. Because after designing, the next stage is to mobilize to site. And when you mobilize to site, it simply means that construction has started. And there are several risks involved. Risk of delay and in meeting the work program, risk of not honoring the IPC interim payment certificate, by that is for the employer now, and risk of not even being able to hand over the site to the contractor. These are all construction risks because the owner of the site, the owner of the job, must show the contractor a space where the project has to, be situated. And if it doesn't do that, what will be the contractor's remedy? Okay, so it is not a risk that you can now shift to the contractor. No. And then there is this risk of getting approvals, licenses from the authorities, licenses and approvals from the authority. Whose job is that? Sometimes, depending on where you are looking at it from, you might think it is the employer's responsibility. That depends on the kind of contract again. And sometimes it might fall on the contractor, depending on the type of contract that you are doing. So that would help the draftsman to know where to place that risk on. Okay, and you also have some other types of risk that you need to look out for, which runs across the entire breadth of the contract. So, but I can see you're a bit uncomfortable with time, so I may not want to go into all that now.
Yes, thank you, Mr. DK. You're very correct. If we do have time after we've run through our questions, etc., we may come back to this because as we know, things like insurance is very important. You've mentioned licenses, payments, etc. If we have time, we can delve deeper into this, and maybe the participants may have questions. So we'll leave it to that and move on to the next question and see how we do with time subsequently. So sometimes the contract has started, or the project has started, should I say, and maybe something goes wrong, etc., and there's a need to change parties. What would you advise in drafting the construction contracts to make room for the possibility of changing parties or reassigning tasks to third parties, maybe not originally part of the contract, or subcontractors, etc.? What do you have to say about that, and what advice would you give at the negotiation or drafting stage, and then maybe the project has already commenced and then something comes up and there's a need for that?
Okay, well, that means there has to be a negotiation clause in the contract in the first instance to enable you now consider new challenges. It's possible because you cannot foresee everything. And if you have that as a safety valve in the contract, you can always make your request in accordance with the contract. Because if it is provided in the contract, there will be a procedure to be taken when such an event happens. And my advice is that you follow what the contract has specified as to how you can introduce new members into the contract. Is something that is doable.
Thank you very much. So we'll move to payments to a degree. So obviously we've established a relationship between the employer, contractor, subcontractors, etc. Now there's a clause, or should we call it a term, in the payment section where it deals with payment, where there's what called a pay when paid, and even in some jurisdictions, pay if paid. Obviously, in most instances, it deals with, the relationship between, for instance, the general contractor and the subcontractors, stating in a nutshell, and I'll let you, speak to that, kind of trying to allocate the risk of payments or non-payment, as it were, from the employer to the subcontractor in some instances. But of course, subcontractors push back on that. And it's an intricate balance that needs to be achieved in that respect. And obviously, it needs the input of what should I call it now? Seasoned draftsman, or a lawyer that knows what he's or she's doing. What are your thoughts on that? And would we see that more in public sector contracts or private sector contracts? I know we'll see in both. I think the question more is, what can you do? Would your response in either case, public or private, be different, or it's still the same approach that should be taken? Thank you.
Thank you very much. Pay when paid is an old concept, and there are a lot of dangers inherent in that practice. One of it is that is like a killer shot to subcontractors. These subcontractors are smaller entities. They do not have enough, they don't have the kind of risk appetite that the main contractor has. They don't have a financial muscle, kind of financial muscle that the main contractor has. So they need money all the time in order to service their obligations under the contract. And when you say pay when paid, that means the contractor will only pay them when he receives payment from the employer. And this contractor might be a big concern that has credit facilities all around him. And he will not feel it because he has already factored it into his bidding document. That, well, this is a government contract and government doesn't pay on time. So he puts that as part of, he builds it in, and is able to absorb the shock when the payment doesn't come, because is already aware. But a small subcontractor, you probably engage to do one thing for you here and there in the building, and he needs that money to remain in business. And you now tell him that you will not pay him until you are paid. Of course, you run him out of business, and that's the reason why you see a lot of subcontractors are, they become insolvent. Because insolvent is very hard on subcontractors because of that concept. But now we are shifting away from that concept. Like you said, that a lawyer that knows what he's doing is able to play around it. Yes, we're not moving away from pay when paid to another concept, which is, let me remember what it is. It is, yes, pay and complain later. We are moving away from pay when paid to pay and complain later. So if you are a contractor, you have engaged a subcontractor, and then the subcontractor has given you his invoice, and you say you cannot pay because the employer has not paid you. It's no longer tenable, because that reason that the employer has not paid you is for a later day. You can give that reason for a later day. But the important thing is that you just have to pay the subcontractor and complain later. Okay? So with that, the subcontractor is able to remain in business. So that when you are doing your drafting, you would know that we are shifting away from pay when paid to pay and complain later.
Yeah, it sounds good, Mr. Dickey, but as I said, it's always, and with not just construction law, all types of drafting, negotiation of contracts, etc. A lot of times it boils down to the power of the negotiator or the power of, the other party. So in instances, I mean, you've already pointed out the subcontractor is quite small on the scale of things when you look at, their financial power, their ability to push back on, terms in a contract, etc. So in practice, is it plausible for in quote now, I'll say small subcontractor to push back and say, no, we're not doing a pay when paid. We will do pay and complain later, knowing fully well that the contractor, general contractor, wants to also protect, itself. You've already said, there are other ways of doing that, insurance, etc., but protect itself against, non-payment from the employer or the owner. I mean, we've seen a lot of government contracts that, eventually they get paid, but it takes a long time. So is it fair also to expect the contractor, the general contractor, to, take on that risk fully Is there a middle ground? I mean, I don't know. I would really like to know if there's a middle ground to be reached here, because we know that the negotiating power of the subcontractor is not as high as the contractor, and definitely not as high as the employer. So what do we do? How do we strike a balance in this type of
Yes,
situation?
there's a safety valve. There's a safety valve for the main contractor, in the sense that, well, you can also introduce a clause into the contract that we call name borrowing clause, in which case the subcontractor can borrow his name and demand from the employer whatever services, whatever invoice he has for the job he has rendered or for the services he has rendered. So he can now, instead of the subcontractor hiding under the main contractor, he now sits in the position of the main contractor and makes a demand directly on the employer. So some many contractors allow that, just to give them a breathing space from these numerous subcontractors that trouble them like bees all the time.
That sounds good. That sounds good. We need to move on, unfortunately. Maybe we'll have time at the end to go back to this if anybody wants to, discuss this in further detail. But we need to move on. So we've spoken about HSC, health, safety, and environment. It's one of the things that we need to look at carefully also during construction projects, because of course there are lots of health hazards, etc. Construction is a dangerous, business, as it were. So are there, existing codes that apply, specifically to this industry? Are there, licenses that one would have to get before pre-project, etc.? You've already spoken to a degree about that. You touched on it when you were talking about risk allocation, but we just want to, touch on this a little bit because it's quite important. What would you say in this respect? And what provisions are there critical provisions to be included in the contract in this regard? Thank you.
Very well. Honestly, quite frankly, we are not doing very well in this jurisdiction. We are not doing very well in terms of HSC because we do not have very good laws, regulations dedicated exclusively for HSC. What you will have here is bits and pieces. For instance, you can have some aspect of HSC in the old Factories Act, and Factories Act is as old as you can think of, well, quite a bit of HSC provisions there, and some states have also kind of enacted their own laws on safety, like the Lagos State government has a Lagos State Safety Commission. So it's not just for construction, but for every other area that involves safety of life. That commission is there to give direction as to what, especially for construction industry, that's what we're talking about now, as to what should be obtainable at a construction site. When you are erecting any project. For instance, they are the ones in charge of signage in a construction project of that has some significant value. You see the signage that is mounted in front of the project, and it gives you the names of all the companies or persons involved in that project. You see the name of the main contractor, you see the name of the client, you see the reason why the client is doing the project, you see the quantity surveyor, you see the project manager, and all that. So that is a statutory provision that you see that is there. And the question, that issue of having a helmet when you are entering a construction site, for you to wear a helmet, and the project has to be scaffolded and all that. These are some of the rules that are supposed to be enforced in construction sites. Like I said, we're a bit behind in this area, and even the commission, I don't know how much it is doing at the moment to ensure safety in construction workplace. I don't think we've achieved much, but on the other hand, at the federal level, there is the ILO convention on safety, which kind of outlined some of the things that are supposed to be present to safeguard the lives of construction workers. You know, because that one is not just for construction workers, but it covers every other aspect that requires safety. But again, construction is just an aspect of workers. So it also involves them. I think that is Convention, Convention 80 of 1981. Nigeria ratified it in 1994. But there is no local legislation yet to back it up. And there's quite a number of other conventions that border on occupational health and safety by the ILO. I think up to date, Nigeria ratified about 40, but renounced 10. So I think about 30 is still in force in Nigeria, but no local legislation to back them up. So it is like something that you may not be able to enforce, except when the issue has to do with taking the matter to the National Industrial Court, which expressly is given the power to enforce those international conventions, whether Nigeria has supported them with legislation or not. So that is a way out. But you're talking about how do we get these things into the contract? It is not only the ILO convention that made mention of safety. We also have the National Building Code, for instance. There's a safety provision, occupational safety provision in our National Building Code. Of course, you know that has been in the works for over 20 years, and up to now, it has not been concluded. But what is there is that you can yank off an aspect that you think is good for your contract and include it in your contract as well. The same thing happens with the ILO. The ILO convention, the area that is also useful for to you, you can also borrow from there and add it to your contract. Thank you.
Thank you very much for that. Sorry, I'm cussing in. It's just that I'm looking at the time and we're running out, so we need to speed it up a little. But what I hear is, there's room for advocacy in that area. And it's something our committee can even take on, Mr. Dike, and you are an able member, maybe some advocacy pushing for more focus, more spotlights on HSC provisions in the construction industry, because it's important. And we see many cases where, HSC, basic, standard, what do we call them? Standard adoptions are not, taken into consideration on sites, and it's quite, the results are quite horrendous in terms of damage or injury or even death to construction workers. So it's definitely an area that we need to look into and maybe advocate for more attention. Thank you very much. We need to move to the next question. I'm trying to hurry up now. A very important concept in construction contract: retention. We hear that all the time. There's always an argument of, okay, how much in terms of percentages, for how long is the retention period, and how it ties into, the defect liability period, etc. Without wasting much time, could you just, explain in a nutshell that concept of retention, how it, ties into construction contracts, and what an ideal retention clause, for instance, the elements that it should contain? I know we're running against time, so as succinctly as you can do it. Thank you.
All right, fine. Retention clause is a concept that allows the employer to keep back a fraction of the contract sum. Instead of paying everything to the contractor, it keeps back like 5% as retention. And it is meant actually to take care of the fair liability period. After the project is handed over to the client or the employer, there's a period that is allowed for defects to manifest, maybe depending 6 months, 12 months, it depends on what the contract provides. So it is only after the end of that period that the employer is now going to return whatever is left out of.
Mr. Dike, I'm not sure if this is from me or him. Endurance or Rex, can you confirm where the problem is from?
I think it's from his end, probably have a network issue. But he's trying to join now.
Okay, all right, we'll just give it a minute. I don't know if Mr. Odom is there. As Able San, a learned silk, my bad, my apologies.
Yes, I'm here.
I don't know if you can help us fill in until Mr. Dike comes back for retention.
Yes, Mr. Dike was talking about the purpose of the clause on retention, and that is what the employer will normally keep back. It's usually stated in the construction contract, normally 5%, sometimes a little more than 5%. For 6 months, sometimes longer, but minimum is 6 months. For the manifestation of defects, we call it the defect liability period, after which the contractor applies for the retention and the retention is paid, less tax and VAT, usually, as the contract would have stipulated. So it's a weapon, a safeguard for the employer, and it's often recommended. There's some contracts where you have as much as 10% kept aside as retention. I've stumbled on some contracts where they even prescribe up to 15%. We'll criticize that as well, so that the contractor is not cash-strapped. So normally 5% of the contract. And the defect liability period, normally 6 months. Yes.
Thank you very much, our able learned silk, Mr. Odom SAN. Thank you.
Thank you.
That
Thank you,
was
Chairman,
very...
Oh, it's back, yeah.
For doing a good job.
Sorry. Thank you, Mr. Chairman, for stepping in. That's part of what we see in construction. Sometimes you see disruption and delay. So this is part of the disruption in the construction project.
Absolutely.
I'm so sorry about that.
No problem. It's good to have you back, Mr. Dike. So we'll move away from that and basically ask the last question. I'll try to combine 2 questions together so that we can give the audience some time to ask questions. We don't want to run over time too much. So adjudication in a construction contract, we know that usually arbitration is favored or used most times, but is that always the case? And in what instances would you advise otherwise? The other part of that, because usually, the governing law and the dispute resolution clause are never too far away from each other. So governing law, I just want you to touch a bit on, contracts that have maybe an international flavor. So the parties are from there's a cross-border element, as it were. How would it be determined? Of course, if it's, for example, a public government contract, there's really not much anybody can do about it in terms of the governing law. But, you know, in your experience, what would you say in terms of negotiating that and also for adjudication? So it's 2 or 3 questions in one, but unfortunately, you have about 3 minutes to answer that, to do justice to that. Thank you.
All right. In terms of the governing law, is quite a bit of a complex area. When you talk of choice of law in a contract, you are looking at about 2 or 3 types of laws as a governing law. One, you have the substantive law, the law governing the substantive contract. And then they also have the law governing the dispute resolution, for instance, the law governing the arbitration, and the law governing the arbitration agreement. These are all governing laws, and they have to be carefully negotiated in cross-border transactions. And if you do not carefully negotiate with what you have at the back of your mind is usually that, well, wherever the contract is performed substantially, should be given that privilege of having the governing law instead of taking the governing law to a third state. What I mean by a third state is a neutral state that none of the parties came from. Okay, so be that as it may, it's always a tug of war to get your own law in, because the other party will also want to get his own law in. So sometimes you say that, okay, there's an understanding that, okay, you take the substantive law while I take the dispute resolution. Oh
dear. It appears we have lost Mr. Dickey again.
Law, choice of law.
Okay.
But is of conflict of law, and it is not an easy task for you, for anyone to deal with when issues arise. So it's always better to, instead of losing out completely, you can share it with the other party. And then, okay, let me move quickly to issue of arbitration and adjudication. Arbitration is usually the preferred method of dispute resolution in construction contract because it is party driven, because the decision of the arbitrator, the award, is final and enforceable. It's quite unlike many other types of alternative dispute resolution in the construction industry. Arbitration appears to be the favored method of dispute resolution because it is arbitration clause is usually seen as a stabilization clause because it stabilizes the contract. In case any party wants to default, the other party knows that he will have adequate remedy, he has adequate protection. And for adjudication, adjudication is a midway between negotiation and arbitration. It's just like a stopgap for parties to explore. So that you don't run into the expense of arbitration, because arbitration can be expensive sometimes. But adjudication is fast, is cheap, and simple to administer, and it has a shorter period within which a decision must come out. Sometimes as little as 28 days, a decision from an adjudicator has come up, but then it's an interim decision when it comes. It's not final. It can only become final if there's no protest about that decision within a given period of time, and then the loser is foreclosed from complaining. Is that a question? That's a third question, right?
No, that's it for now. So we want to move on to the Q&A so that the participants can also feel a part of this session, because we're drawing very close to the time. The SBL Secretariat have
Yes.
graciously given us a few extra minutes over 3 o'clock, but we want to keep it as short as possible. So yes, please put your questions in the Q&A box. Thank you so much, Mr. DK. We've learned so much from you today, and your wealth of experience has been very, very positive and knowledge building for us. For me, I can speak for myself, and I'm sure all the other participants will attest to this. So I'll quickly try to run through questions. We probably can't do all of them, take all of them, but be assured that the Secretariat of the SBL, NBA-SBL will collate these questions and try to put out, share with Mr. Dike, and he'll try to put out responses through one forum or the other. So we'll go straight to the questions. Thank you. This is from Anonymous. Great webinar. Is there a standard construction template you can share to participants? Mr. Dike?
Is it construction contract templates or
yes, yes.
If
Standard
I'm trying to understand the question.
Yes, templates, basically. This is what Anonymous is asking.
Yes.
I'm sure that can be looked into.
Yes, we'll look at the Secretariat will look into that, and of course there are quite a number of them. We can avail our colleagues who are in need of it. Yes, we can. Yes. Okay,
so there it is. You've heard Mr. Dike, and of course through our committee as well. Please join our committee. It would be of good. It would be of of advantage to you. If you're interested in this area of practice. So Ijoma Nanta asks, are there instances where a consultant can double as a subcontractor? For example, where the subcontractor is an architect or an engineer professional engaged by the contractor to carry out the job. Are there instances where the consultant can double as a subcontractor?
Well, that will be conflict of interest because he's working for someone. It's not advisable. You are appearing in one capacity, and you now want to appear in another capacity that might conflict with what you are doing. It's not advisable. It's not.
Yeah, although we do see it a lot, even in smaller projects, let's just say, for houses, etc. The architects and the engineers, the architecture firm basically does all the work, and they've also, kind of subcontract. But as Mr. Dike has said, it's not ideal. It's not ideal practice, and there is a conflict of interest in there. So this person says, in a nutshell, my question is, and this is anonymous, is construction law an evolving aspect of law? Mr. Dike.
Construction law is as old as law itself. It's been around for a long time. It's not evolving, but the only thing is that lawyers did not develop interest in construction law early enough. So it allowed other professionals to occupy the space. Of course, nature abhors vacuum. So what you find is that they are already there and they understand the contract very deeply. That's why I said to you earlier that for a lawyer who is drafting a contract, it is advisable that you also join from the onset. Don't wait until the contract is negotiated and then you are asked to put together the bolts and nuts, and then you structure the contract. No, you might not understand the nuances of that contract. Okay, and so that's why and you might continue to look at like an outsider until you get involved to understand the business of your client. So construction law is not new at all, but it may be lawyers are waking up to it quite a bit late.
Yes, thank you, Mr. Dike. So to the next two questions, Anonymous is asking for the standard template for government contracts, and Additional Adegbite is asking, suggesting that, there's a display of a sample of standard forms referenced in the presentation or in the seminar. Contact our committee, that's what I would say.
Yes, I do not have them. Yes, absolutely. I do not have them at the moment right here. So, but the committee can do that later.
Okay, this is also anonymous. Considering the position of the subcontractor in the project, is it usually the case that they are represented in the negotiating process, either by themselves or their lawyers? Subcontractor.
Yes,
Hello, Mr.
sometimes
Dike. Okay, sorry.
like I said, okay, I said that usually the subcontractors claim through the contractor. They claim through the main contractor, and it is actually the main contractor who employs them. So they report to the main contractor. So the main contractor protects their interests, and sometimes they are part of the team of the main contractor. Not even sometimes, all the time. They are part of the team of the main contractor. So they're already there, and they make their input. Yeah.
Thank you, Mr. Dike. Just, speeding along, Kayode Leshin asks, I think, 2 questions. In every tender requirement, apart from the requirements which are peculiar to the type of contract, why are there general requirements by BPP in the tenders journal, regardless of the value or volume of the construction contract? That is no distinction in government construction contracts as to whether it is a big or small one. Why is this so? And number 2, is there a recommendation that could be made in this regard, particularly in the interest of upcoming contractors?
No, as I've already said it, that PPP is in charge of large volume contracts. They don't do small contracts. They don't do small contracts. I think the threshold at the moment is like anything above 1.5 billion. It goes to the BPP. Anything below that goes to the Ministerial Tenders Board. Okay?
Okay.
That's each ministry will handle, each government department will handle that. It can't be escalated to the BPP, because once a project is escalated to the BPP, it will go before the Federal Executive Council. Right? But if it is the minister that is going to be in charge and award the contract, it goes through what they call Ministerial Tenders Board, and there is a separate standard form for that. All right, so the division has already been made.
Thank you. Mohammed Abubakar asked the question. Mohammed, that question has already been answered by Mr. Dike earlier in the contract. The key terms that must appear in a construction contract and what must be considered while drafting them. I'm hoping that this is recorded and is still available for the audience to refer to later. Your answers will be in the recording, Mohammed. Thank you. Afam Okeke asks, how efficient has arbitration been in construction disputes in Nigeria, and have they resulted in the resolution of disputes without parties proceeding to court after huge expenses have been incurred in arbitration?
Yes, arbitration is very effective because the arbitration of construction disputes has a special place in construction. There are some people that are actually specialists in resolution of construction disputes, and these people have a background, that they have some skills in construction contract, and then they now join it with arbitration so that they're able to understand the dispute. Because I mean, for parties to have confidence in you as an arbitrator, you must be able to understand them, understand their language, and understand where they're coming from and where they're going to. That is the first thing in dispute resolution. If you lose the confidence of parties, you can't resolve that dispute. So for construction disputes, there is what they call construction arbitration. And there are some specialists in that area that have always churned out volumes of decisions that the court simply adopts, because, I mean, if you now want to open it up, you probably have to acquire the kind of skill they acquired before you're able to open that kind of award up. But what we see here is some people will just challenge awards for the sake of challenging, even when they know that it's unmeritorious. So I mean, so they will just challenge just to delay. But at the end of the day, if you look at the decisions that have been coming out of our courts lately, you can.
Hello, Mr. Dike. Yeah, I think maybe that's a sign, because I was just going to ask one final question because of the time.
Any award that has been set aside. by the court.
Yeah, Mr. Dike, we lost you for a minute. As I was just saying that we can only take one more question. There's so many questions. So please, Secretariat, could you please help us save those questions, and then we'll find a forum through which we can share responses from Mr. Dike. So the last question I will take before handing over to our chairman is from Jennifer Omone. Is it possible for the employer to join the subcontractor in an action against the main contractor for defects in the project caused by the subcontractor?
Well, if you can join it, I doubt if it's a necessary party, but you do not have a contract with the subcontractor, the employer. The person you have a contract with is a contractor, and the contractor is liable, vicariously liable for the acts of the subcontractor because he's working for him. All right, there's no separate obligation towards the employer from the subcontractor. And when you look at the construction contract, you don't see the signature of the subcontractor there. You only see signature of the employer and the contractor. So privity of contract, of course, wouldn't allow you to now proceed against the subcontractor when it's not a party to the contract, so to speak, but it's just part of the contract.
Okay, thank you so much, Mr. Dike. There's so many questions here. People still asking you questions about the risks. Could you point out more risks? People, there are just so many questions. The last question about joining the construction committee, please just reach out to the SBL Secretariat, and they would give you the emails to send your number, your details to, or the WhatsApp group to join. Thank you so much for your time, everyone. I thank you, Mr. Dike, for your time. You've been very enlightening. Your insights have been very enlightening and very helpful. I'm sure the other participants will attest to this. I will now humbly hand over to our able chair, Mr. Andrew Odun, SAN, to wrap up and maybe I don't know if our overall chairperson is here to close out. Thank you, everyone, and we really appreciate your participation and the time spent with us today.
Thank you so much, our own Mr. Dike, and Yetunde, the great Yetunde. Thank you so much. We have all enjoyed this edition. Personally, I've learned a lot. And I'm also speaking for all the participants. It's a great outing. And from my screen, I see that we have over 120 participants. And thank you so much, all the participants, both in our country and beyond. Thank you so much, Lady Ozofu Latunde, for this opportunity. Thank you, the Secretariat of SBL. Keep a date with us. Come and join us in this committee. We have a lot to do, a lot to learn, a lot of money in it. We're going to make a lot of money. So this is a veritable practice area for lawyers, young lawyers, old lawyers, average lawyers, lawyers who want to go international. Please come and join us in this committee and enjoy what we enjoy, the knowledge, and also the opportunities that abound. I said at the beginning that we're grateful to IBA, ICP for your collaboration. Thank you so much, everyone. Keep a date with us. Our national conference is coming. Another webinar is coming. This committee loaded with activities. Thank you for joining us today and also in the future. Thank you. Over to you, Yetunde, moderator.
Oh, well, that's it. Thank you, everyone. I'm not sure, as I said, if any member of the council would like to say anything, but we thank you for your presence here and the support. Barring that, the session is now over. Thank you for your patience and time, everyone, and enjoy the rest of your day.
Thank you.